Now, for this year's lecture, we are honored to present none other than Professor Susan Silbey, the Leon and Anne Goldberg Chair in Humanities, Anthropology, and Sociology, and Professor of Behavioral and Policy Sciences in the Sloan School of Management. Now, typically when a scholar of this stature is introduced, the person doing the introducing says something along the lines of, this person doesn't need any introduction, and then proceeds to give a loquacious introduction detailing their every accomplishment. But in this case, Professor Silbey really doesn't need an introduction. We have all been influenced in some form or fashion by her work over the years. It's rare to have a scholar who has had such a profound influence on a discipline as she's had on the sociology of law. So detailing her accomplishments, publications, awards, and the breadth of her influence would take the entire time allotted for this lecture. So I'll simply say that we're deeply honored that she has accepted to join us today, and relinquish the floor to her now to deliver her lecture, Pragmatic Regulation, Governing Inside the House of Science. Over to you, Professor Silbey.
Thank you, Michael and Carlo, for this invitation. First, shall we share the screen? Okay, so as I was about to say, I am deeply, deeply honored to have been asked to give this second public lecture in honor of Professor Banakar, a towering figure in the sociology of law who worked to reconcile, I would say, the empirical and theoretical dimensions of our field. In the beginning, he said he expected, or perhaps he had hoped, that we would develop a discipline with clear boundaries and topical dimensions, but ultimately he embraced the notion of a large tent in which the various participants and lines of research could, let us say, dance well together. The dance being an insistence of doing and analyzing law in context. Although there is much to say about Professor Banakar's important work on globalization, ethnic and racial discrimination, political and social rights, as well as cultural and religious dimensions of legal systems in transition, for my remarks today, I'm going to build upon Professor Banakar's concern with the ways in which the sociology of law can inform public policy. And following his general instructions, I begin with some context. I have a PhD in political science. I was for 26 years a professor of sociology, and for the last 22 years, I have been a member of MIT's anthropology department, and I teach the doctoral courses in organizations and research methods in the Sloan School of Management in the Work and Organizational Studies group. Across these many disciplines and many decades, my scholarship has been exactly the same. I study how law works. For these 45 years, my research has explored how law, as text, as organizational practices, as a historic institution, develops in response to the demands and contributions of ordinary citizens, how law is made, we might say, from the bottom up. Although law is, as you well know, a professional occupation and a sphere of expert knowledge for thousands of years, my contribution to the social science of law has been to demonstrate how the long-lived durability of legal institutions derives directly from the multiplicity of citizens' interests and narratives inscribed within the law, rather than focus on what official texts claim to be the law, what socio-legal scholars colloquially call the law on the books, I look at what those texts, be they statutes, regulations, cases, set into motion. Although this dialectic animates socio-legal scholarship, the law on the books, the theory, and the law in action, the empirical, are not discrete and divergent spheres. They are tightly coupled, entwined in popular consciousness, and thus as both text and action, both ideal and practice, the law is stronger and more durable and longer lasting by this entwining. My current work falls under the rubric of regulation and governance. I try to understand how regulations are experienced by the regulated populations, organizations, and individuals. The traditional regulatory approaches tend to produce, historically this has been so, sort of one-size-fits-all regulatory frameworks that gloss over the differences among organizations as well as within organizations, perhaps too often relying on command and control style enforcement. There is, however, an emergent stream of contemporary scholarship and policy that attempts to reverse this one-size-fits-all tradition with such models as performance-based regulation, responsive regulation, risk-based regulation, light touch regulation, and so on and so on. I saw a model some months ago with a beautiful wheel of 22 different styles of regulation. These newer approaches rely on the regulated organization itself to design, set standards and guidelines in homegrown systems that achieve regulatory expectations, hopefully, while also providing an account to regulators of how the organization produces compliance. Such approaches require, at their core, that organizations internalize the regulatory work that used to be done exclusively almost by governments, but they internalize the requirement to set standards and guidelines, to develop policies and procedures, auditing, training, correcting, what historically may have been government responsibilities. Now, this abundance of approaches might signal the political preferences of our times, or as likely, it might also reflect a deeper fear of the coercive power of the state, or it might be a response to the failures of the previous models. These approaches might, in that sense, represent success of the sociology of law, as well as public policy research, responding to what we have learned over these 100 or so years about where regulation succeeds and where it fails. Whether traditional or innovative, it turns out, there seems to be a common policy discourse and scholarship that continues, despite these innovations, to describe wide variation in compliance. And the explanations are even more varied. They range from accounts of inconsistent and lax oversight to industry capture through poorly designed legislation and misaligned incentives, and sometimes just outright corruption. Sometimes some of the research describes inadequate organizational resources that prevent organizations from taking on these responsibilities. And sometimes the research describes simply explicit resistance by some firms and industries. Much recent scholarship and policy advocacy, especially from the economists, has responded to this vast array of observations by recommending nudges, N-U-D-G-E-S, nudges, little pushes, to push behavior to reduce what are anticipated risks. And this is where our research for the last several decades begins. Through a series of studies of environmental, health, and safety regulations in several universities and dozens of research laboratories, we have been trying to identify the circumstances, that always important context that Professor Banakar urged us to pay attention to, where compliance may in fact be achieved, as well as where it may be failing, to identify the different conditions. We look at what we think might be a hard case. We look at this hard case, and we describe science as a hard case, where there are efforts to impose regulations on what I call the house of science, the laboratory, the research laboratory, a space normally protected by academic freedom, by investigator autonomy and independence, that a degree of status, independence, and autonomy that is not afforded to most other occupations and industries. Now, scientists do, across most of the world, they enjoy unusual degrees of autonomy in setting their professional agendas and their research methods. Our research ends up describing how scientists forgo, they give up more common resistance to organizational nudges by deferring to institutional pressures and requirements for surveillance, inspection, prescribed training programs, annual retraining programs concerning radiation, animal safety, biohazards, chemical waste. The question we ask ourselves is, why do these scientists comply when resistance is more common? And we can document the resistance to many other forms of regulation. So what I want to do today is I want to first locate this current project in my previous work, which Michael was nice enough to refer to, my work studying law in everyday life, and to try to show you how a study of ordinary citizens becomes the study of elite scientists. I'll do just very quickly my research methods, and then I'll present 3 particular results from these many projects. I'm going to describe how biologists and chemists respond differently to legal regulations. I might spend the most time on that. How scientists use their expertise to interpret risks and the relevance of rules, and how status creates privilege to forgo compliance. And then I'll conclude with some remarks about how pragmatic adaptations help govern what we might think of as the gap between the law in the books and the law in action. Now, my previous research culminated in a book, which I gather some of you read, The Commonplace of Law, Stories from Everyday Life. In that work, we asked what the law means to ordinary Americans and how can we explain its power and durability. What is the law after all? This is an obvious question in such an audience, right? Well, you all know what it is, right? Here's a statute. This is a statute from the Massachusetts General Laws, right? It could be a local ordinance. As socio-legal scholars, these are things we've actually read, right? And we've analyzed. But to most people, to ordinary citizens, they don't read the statutes, they don't read the laws. So if very few people know this tangible, concrete evidence of legal work and of requirements, what do they think the law is? How do these dense, unfamiliar, obscure, obtuse objects produce stability, legitimacy, reliability? That was our question. Well, maybe they think about this document, a little bit more familiar, but maybe to you in Europe, these. They might think about constitutions. But we know that these texts, they're, they may be more familiar, but they're subject to enormous dispute and contestation, as we know, right? Or maybe they think about this. They think about courts, the International Court Justice or the United States Supreme Court. But just like statutes and constitutions, most people never show up in court. The data in the United States show that less than 3% of the population will ever appear in court, whether as a juror or as a litigant. So what I have done in my work is, instead of looking at the statutes and the courts and the litigation, is I've tried to answer the question of how law endures by how it is known, how it is experienced, and how it is interpreted by people in their everyday lives. The law that I study is all around us, in my university office where I'm sitting now, or in classrooms, in the corridors. We live in thoroughly legally constructed spaces. And my contribution to legal research and the sociology has been to study law from the ground up in the routines and habits of everyday life. This work is sometimes described as cultural analysis of law, showing how there are elements of law embedded in all sorts of activities. These signs and symbols connect in often unseen and untraceable ways, but we all recognize it for what it is: a restriction, an instruction of what we're to do at any moment. For many years, I spent my life documenting the ways in which we, the citizens and just ordinary social actors, not lawyers, not police, not judges, how we, the citizens, participate in the rule of law, and how we enable the law to coordinate our lives. You might think that for law to be applied or shape people's lives requires enforcement agents, the police, regulators, all the apparatus of compliance officers that I have been studying these last decades, upon which many regulations actually depend. And to some extent, the law requires these active enforcement. But it turns out that most of the time, most people go along without anyone threatening force, without dispute, without opposition or resistance. And because most of the time, most of the people go along, and legal violations are actually quite rare, we speak of the rule of law. That's the subject we study. And this is the particular one I have been studying: research laboratories. They are thoroughly legally constructed spaces, requiring certain behavior, certain clothing, certain activities. So think about it this way. There's a wide distribution of encounters with the law. And I've been showing you the signs of where law is. Here it is on, let's look at this baby carriage. 1, 2, 3, 4, 5 signs, signs specifying the construction and uses of this baby carriage. I think this is one of the most beautiful ones of the pervasiveness of law, okay? So that the law is helping to construct baby carriages, buildings, roads, controlling radiation. It turns out that the consistency of people's actions with these written rules varies. And we can imagine this variation like a normal curve, all right? Just a Gaussian curve, where some of the interactions follow and comply with the law, some violate or maybe just not quite compliant, and others could be legalistic, right? When people, sociologists and other social scientists began to look at what actually happens in the name of the law, we conducted those empirical studies that Professor Banakar wanted to join with theoretical treatises. And what we observed was a giant gap, as I've already said, between what the law said and how it was applied. And as I pondered this persistent observation in socio-legal studies, I realized that we were actually looking at only one tail of what was a distribution of different kinds of legal encounters. We were looking at only law's failures and describing that in most of our research. So when regulations were inconsistent or fail altogether, such as, unhappily and recently, the Boeing 737 crashes in Indonesia and Ethiopia, a direct failure of the regulation by the FAA, or as importantly, the Fukushima nuclear reactor, or the Deepwater Horizon collapse in the Gulf of Mexico. But we don't need to have such giant disasters to see this dark part of the tail. We have it whenever police arrest with little intention of prosecuting, or fail to arrest when they observe a crime, or when courts convict innocent people, as the recent wave of exonerations in the US shows. At the other end of this curve, we have events where law is followed strictly, if I might, a little ethnocentrically, in the recent conviction of the Trump Organization for tax fraud, finally. Sometimes the law can be followed so strictly that its procedures and its purposes are lost. And this is the frustrating bureaucracy where filling out forms is more important than what the activity the forms are about are meant to initiate. What Friedman and Ladinsky over 50 years ago described as legalistic law, all right? The point I'm trying to make is that in the enormous variety of situations that the law touches, some are clearly closer to legal expectations than are others. And of course, it might turn out, if we ever could do such a count, not to be a normal curve at all. But for sure, there are smaller numbers at the tails. We know, for example, that about 5 to 10% of actors constitute about 95% of the observed criminal activity. So when I realized all of this, we asked ourselves, how can the law in action be so different from the written rules and still sustain so much allegiance and legitimacy? Okay, when I realized we were looking at the tails of a distribution, I began to use this image in my teaching and in events such as this to describe the variations in what we were studying or knew about the law. And this became my research agenda, to look at the hump instead of the tails. So I began with work in the Attorney General's office of Massachusetts, I moved to lower courts. I then studied alternatives to law and then to ordinary people going about their lives. How, we asked, did ordinary people think and talk about the law? And this became the study of legal consciousness. We documented narratives of legality that circulate in popular culture. Okay, now, this is a model that we produced and seems to travel widely. But what we learned was that over time, the work on legal consciousness suffered from too narrow a focus on individual thoughts, and that there was too little attention to institutional and structural influences and supports. We were encouraged to look elsewhere. One, we received nice compliments on our work, but we also received criticisms. One of the criticisms was to look inside organizations at how competing normative orders would shape interpretations and responses to law. I thought this was reasonable. We had studied individuals. It was now time to study them directly in organizations that might have competing norms. We were also urged to study elites rather than ordinary citizens. Well, I didn't like that criticism. I thought, that misunderstood the import of the commonplace of law. But I thought, well, when people tell me things that I think are too harsh or something, I then sometimes get upset, but then I want to respond. So I decided I would study elites, but not what my critic wanted me to study, which was lawyers and judges. I decided I would study cognitive elites. I would study scientists. And then I asked, is the law experienced differently in the work of elite scientists than it was in the daily lives of ordinary Americans? And we began this work to study the regulation of science. Okay, and it turns out, as I've shown you a little bit with some of those images, in many ways, scientific spaces are no different than most others. They are saturated with legal regulations. And so we began 2 decades of work following the enforcement of environmental health and safety regulations. I work with many graduate students. Their names are on this screen. And we engage in multiple methods. We observe in laboratories and in meetings, we interview, we use archival data and organizational records. We've also conducted surveys and interviews with environmental health and safety managers at 174 American universities and 1 French. We haven't expanded internationally as much as we had hoped. Okay. And what have we found? Well, that's what I want to tell you. Okay. In this first set of results, in a paper called Why Do Biologists and Chemists Do Safety Differently? The Reproduction of Cultural Variation Through Pragmatic Regulation, which just came out in a book called The Pragmatic Turn in Sociology. I want to describe the results here. And it began with what is called a consent decree. I don't know if you have consent decrees in Sweden or in Europe, but a consent decree is an agreement between the government, usually a regulatory agency, and an organization, in which the defendant, the organization, does not admit to any guilt or any liability, but promises not to do a set of actions which it doesn't agree that it did in the past. It's a negotiated settlement where there's no admission of guilt, okay? In this case, the consent decree was prompted by an inspection by the Environmental Protection Agency, okay? The EPA had alleged that the university violated certain provisions of the Resource Conservation and Recovery Act, the Clean Air Act, the Clean Water Act, but as I said, without admitting any violation or any liability, the university agreed to settle the matter without a trial on the facts. And this negotiated settlement took 3 years. 3 years after the inspection, okay? In exchange, both parties were very happy. They were satisfied because they thought, the EPA thought, if it could get this notable university to agree to create a system for managing biological and chemical hazards in their laboratories, they would give it to the nation as a model, and then they would be on a path to transforming laboratory practices across the United States. So this was going to be a solution, not just for this university, but for the nation. And in exchange for the promise to create a system for managing scientists' activities, the EPA gave to the university an unprecedented 5 years to come into compliance. 5 years. Normally, when the EPA comes to inspect and they find violations, you get 6 to 9 months, and then they come back and everything has to be corrected. In this case, the EPA found over 3,000 violations in one university. 3,000 violations. But they never found any emissions, any spills. There was absolutely no damage to the environment. What the EPA found was what they called anarchy. They could not explain what they found. Some labs were models of perfect order, perfect handling of the waste, wearing protective garments, separating toxic from untoxic chemicals. Perfect. The other one was a mess, disaster, too much chemicals, no labels on anything, nobody wearing coveralls. And nobody could explain why there was such variation. And this is really what was the heart of the matter for the university. What the EPA wanted was consistent conformity. All the labs should behave the same way. They wanted clear, transparent lines of authority and responsibility. But they wanted it in a university where there is widely dispersed authority. And as I said at the outset, defining this as a hard case, they have autonomy. And so what was threatening to the scientists was the demand for conformity, the demand for lines of responsibility. And this was the heart of the matter. From the point of view of the EPA, they want compliance. But from the point of view of the scientists, this was a threat to their autonomy, to academic freedom, to their spaces of invention. Okay? So that's the problem which I set out to understand. Would these scientists go along with these demands to change the way they routinely do things and simply comply? Not normal for them. So what I noted when I started observing in one university where the EPA had secured this consent decree is I immediately saw that the scientists were not responding the same way. It turned out that the biologists and the chemists, who together, there are only two departments, but they represented 75% of all the hazardous waste from this university, a university with engineering departments, with 4 or 5 other science departments, with lots of laboratories, close to 300 or 400 laboratories. And it turned out that they didn't respond the same way. At the outset, the biologist was skeptical, if not outright hostile. They were reluctant, they said, and I'm quoting from the field notes, to be burdened by additional demands on their time and their resources that are not part of research. Now, to some people, the law always looks like a hindrance, impeding research. And those who view regulations this way offer dozens of examples of how constrained they are by all the rules and how afraid they are by what might happen with a new, improved system. And they were afraid of the whole notion of a system. A system is simply an information flow and a delegation of responsibilities. But to listen to the scientists, and especially the biologists, they were overwhelmed with budgeting system, with personnel systems, with paperwork and more paperwork. And I'll give you a quote. One researcher explained to me that such outside monitoring is a waste. He said, no one cares more than the researcher to secure the laboratory, to secure the students, to secure the postdocs, and to be sure to protect the animals. And here I quote exactly. Look, he said, it's a big pain. We want the mice healthy. People are going to want them healthy because they can't do their experiments otherwise. He didn't say he wanted the students healthy. The scientists care more, they claimed, than any inspector could, because the scientists have a direct interest in securing the health and safety of their experimental animals. Okay, the spot inspections and detective work of government agencies are a big waste of time. And if the university is going to get into this business, it's more waste. Now, a more typical response, but less global, that was repeated at every meeting that I observed, and I followed the designers of the system from one department to another, is that, and I quote again, my students don't have time for this. They have to do their research, end quote. The message there is loud and clear. That is, that the law, the requirements are external to research. Now, when the management system and the organizational scheme of training and auditing were presented to one group of the biologists, the first faculty member to speak said, why don't we just tell them we don't want to do this? Okay, this called forth a great deal of laughter. The notion that the university could just say no had not occurred to the rest of the group as either reasonable or admittedly responsible, and it echoed, they thought, to Mrs. Reagan, who had the same phrase about smoking drugs. Okay, just say no. All right, the earliest and loudest message was that the safety regime, the law, was external to research. It created unnecessary and costly obstacles. And they said, we are doing important work and we are not the nation's problem. In contrast to this exclusionary reaction, a chemist remarked one day in conversation with one of the biologists, quote, the environmental practices we're trying to get everyone to adopt are not additions to what we do, We have to see these things as part of what we do. We can't be scientists in one way and environmental citizens in another. So the chemists didn't necessarily have greater respect for the safety inspectors. Indeed, it turns out they had less, but their immediate response was that they could do it better because they knew the chemistry better and they understood the science. Now, once the university agreed to hire more people to manage all this, then the biologists were entirely on board and it was just details to work out. So in the beginning, as I said, the biologists said they had no time for this. They need to do their research. The chemists said, no, we do it already and we could do it better. It's part of being a chemist. The biologists said this new role called an EHS coordinator should not be a member of the department, because if they were a member of the department, they would be intimidated by the professors and they couldn't tell the professors what to do. So they needed to have this new position be in the administration who could say to the professors what they ought to do. On the other hand, the chemists said, oh no, we can't have anybody from outside the department try to enforce these rules, because only people inside chemistry know chemistry and know what the nature of the different hazards are, and it cannot be a member of the administration. So the solution was to hire two people, one who would be inside the department and one who would be outside the department, and they would form a team, a partnership. As soon as that was decided, the biologist said, terrific, this is wonderful, let's do it. The chemist said, no, it'll be a long time before we find somebody we like. And it turned out that the first person that was hired for the biologists, they loved that person and stayed for 5 or 10 years. The chemists, they went through 3 or 4 people before they found a person that they would have within the department doing the inspections and enforcing the new regulations. The chemists had already been inspecting labs before the EPA came, because early in the 90s, about 10 years before the inspection, the government had instituted something called chemical hygiene plan, and it had been recommended, not required, and the chemists had implemented it and had been inspecting their labs with their own forms for half a dozen or more years. The biologists said, just tell us what we need to do. We'll use the same form as everybody else. The chemist said the auditing and inspection of the department and the labs would be done by faculty, students, and the new environmental health and safety personnel. The biologist said only this team would investigate. The biologists would have scheduled audits with advance notice. The chemists would have unannounced audits. And finally, the biologist said, just give us 10 rules that we can post above every sink in every lab, and we'll follow the rules. And the chemist said, every lab is different. There can be nothing standard. Well, these two departments, as I said, together represent 75% of all the hazardous waste. They live in buildings next to each other. They share faculty back and forth, biochemists who go back and forth, and yet as a department, as an organization, they responded very differently. The question became, okay, we've observed a variation. How do we explain it? And we explained it with interviews, with history, and with lots of investigation. And we came up with 3 different explanations. If we look at the different aspects of doing science and being a scientist, we found variations in history, in the sociology, and in the practice. And let me just explain these a little bit. Okay? So what do I mean by an explanation from history? Well, it turns out, as I'm sure you all know, that biology is a very modern science and chemistry is a much older science. And it is a discipline that has had an industry for almost 200 years now. And this relationship between the industry and academic research shaped a large part of the expectations. So there is movement back and forth between industry and academia for the chemists in consulting, and this as well as sending students into industry. This created an intimacy in chemistry that is only now in the last 20 years emerging in biology. Part of this shared culture among chemists and what distinguished them from the biologists until recently is their understanding that everyone with whom I have spoken told me this, that the dangers attached to the materials with which they work are the center focus of their work. And this has been part of the discipline for these 200 years. This goes back into Germany and early laboratories in Europe, which were built where they invented hoods and other forms of safety devices, okay? Within the universities, we found archives that this difference in interest in safety issues distinguished the chemists at this university for 50 years, where they have been part of the safety apparatus and the facilities. For the biologists, ironically, their history worked against the concern with safety. If we recall that when recombinant DNA was first made public, actually here in Cambridge, the hysteria that surrounded this invention led for a time to a moratorium on all research. The city of Cambridge shut down Harvard and MIT until regulations could be installed on how this research would be done, with eventually a national conference voluntarily by biologists to set the rules for working with recombinant DNA. Now, they considered the public fears unfounded, but they nonetheless produced a set of rules which eventually became not only rules for the profession, but the ones which the federal government adopted. All right. Now, when the biotech industry began in the 80s and 90s, it's beginning at a time in American politics which is very hostile to legal regulation and hostile to government intervention of any sort. So you have 2 different histories. You have an older profession which recognized its dangers from the beginning, that built in physical safety as well as sought government regulations. In the 1880s, we found documents where the Chemical Association was asking the federal government for regulations. And you have another industry, another discipline, which becomes an industry in a very different neoliberal environment. So another aspect that differentiates these 2 disciplines is what I would call the sociology, the way the labs are organized, the personnel, the space, the resources. Here again, there are significant differences. For example, in biological labs, there are many, many more technicians and permanent lab staff. They have a much higher and steeper hierarchy of personnel in the biology labs. In the chemistry labs, there's just the professor, postdocs, and many, many students, almost never any permanent staff. There are also systematic differences in the architecture of the laboratories, and two items illustrate this. One, in the chemistry buildings, the design of the laboratories was individual. Each faculty member got to determine how they wanted the space arranged. In the biology buildings, all the labs are exactly the same. Okay? There is also a difference in the amount of shared space. Biology building has approximately 25% to 30% of floor space allocated to shared facilities, to shared machines and refrigerators that for everybody. In the chemistry department, there is no shared space. Okay. Finally, there's a difference from epistemology and the experiments themselves. There seem to be very different lab and bench routines in chemistry and biology. Okay? Now, for example, the biologists seem to produce their results through statistical analysis of variation in their samples. Most of the chemists we're observing, and we've been observing synthetic chemists and inorganic chemists, are trying to create and understand a particular singular chemical reaction. Okay? And while some of the procedures are repeated, they do not work in industrial style, high numbers in the samples as the biologists do. Again, the biologists also purchase many of the steps in their research protocols. They use what science studies scholars call black boxes, ready-made processes. The chemists, however, use many fewer ready-made packages or none, and they expend most of their effort what they call unboxing reactions that take place within the tools that are used by the biologists, engineering research, and industry. As one chemist explained it to me, we try to invent a new process, a new reaction. Then that can be used by others, by chemists, but also biologists and industry to produce something they need. But what we do is figure out a generic or universal reaction. In addition, it also appears that the biologists use a wider array of materials and techniques than do the chemists. Okay, now certainly the chemists have lots of materials, there are all sorts of glassware and whatever, but they have less variation in terms of it. Thus, the number of steps, the number of machines, the range of equipment, the use of standard recipes and statistics varies between the fields. This may be a consequence of scale, the size of the object or the matter with which a particular scientist is trying to manipulate. Nonetheless, it may also produce a different set of orientations toward what constitutes safe and unsafe practice and how much they will tolerate intervention from somebody outside. So let me tell you what we take as the results of this. It seems to us that the local organizational and scientific cultures are creating different responses to legal regulation. Regulation turns out to be an organizational resource, legally imposed constraint for the biologist, just like all the shared materials they have and all the packages they buy for their experiments. But for the chemists, it turns out to be something inside chemistry that they need to control or challenges their authority. Okay? The introduction of law into the process of doing science takes on these different interpretations as part of science for the chemists, as part of the context, but not the content for the biologists. By excluding issues of hazard and safety as non-scientific, the biologist's authority is not challenged by the demand to reorganize themselves and be subject to surveillance and auditing and training. The biologist can treat these commands as just another piece of shared equipment, all right? Another technician, a set of externally available resources. And what comes with those resources, constraints, red tape, like the rules they very much opposed at the outset. Okay. At the end, they both produce green laboratories, but very differently. And those differences become important in understanding the role of law, legal subjectivity, and the aspirations of science and the law. Okay? That despite their different interpretations, as I've said, they both defer to the legal authority, but the authority is experienced and imposed differently. And the compliance with training and audit also signifies deference to an authority that science participates in constructing. For the chemists especially, the institutionalization of safety as a governing norm. Okay. Now, there are also contributions in this work for science studies scholars, if any among you are those. This documents the local, place-based, and organizational grounds of scientific practice with a new dimension that hasn't often been observed of what I would call legal subjectivity. And for socio-legal studies, it illustrates how the universal aspirations of the rule of law can be sustained through very different enactment and forms of deference and consent. Specifically, how elite subjects, research scientists, can be seduced through conventions of collegial governance and their local cultures to construct their own bureaucratic confine. Now, I have two more results, but I see that I have been speaking for 40 minutes. Should I do the next two quickly, or should I do want, let me just say quickly what the next two results are. What I show in this very quickly is a laboratory in a medical school in which we identified 33 safety events. They range from wearing the lab coat to use of radioactive materials, to storing and labeling chemicals, to dealing with a chemical spill, to working with lentiviruses, which are very, very highly reproducing viruses, to tissue culture. We found 33 events that they considered hazards. But when we looked further at these, we found, like most studies of regulation, that not all of these practices are followed consistently. So some of them, they consistently follow. Others, they follow on a case-by-case basis, discretionary. Some are just symbolic. They only do when they expect an inspection. And then for others, they make up new rules that are not in the law. And once we observed these variations, we then had to explain it. Please note the method of our research. As I did with the biologists and chemists, we observe what they are doing. We come up with an observation of variation, in that case between biology and chemistry. Here, variation in compliance with rules. And then we have to discover explanations, which we put forward as hypotheses for different kinds of research or other studies. So here we have variation. And it turns out that what we discovered, when you talk to the scientists, you watch them and you listen to them, we know that the law is a regulation that is trying to protect human bodies. They're trying to prevent danger to human beings, and they're trying to prevent contamination of the environment. So these practices, dealing with the lentivirus, which is very contagious, dealing with hypodermic needles and sharps or radiation, they threaten the body. But storing and disposing of chemicals, those are the threats to the environment. But as we analyze the data, which I'm going to show you in a minute, we realized that the scientists have additional risks that bother them. They care about threats to the experiment, whether there be contamination. And this has to do with the rules about refrigerators, about the biocabinet, about cleanup, about the use of the centrifuge. And then other rules they have made up has to do with whether they can trust their colleagues. And this is how they assess what hazards exist, what is being threatened, and what are the probabilities. And we found, and this is the conclusion, that compliance varies with the number of hazards identified. So if you can see this, when there's a threat to the body and to the environment and to the experiment and to trustworthiness, those are the first 15 listed here. When all four are present, they comply absolutely without variation. And these are half legal regulations and half local regulations. But when it is only some of these risks, so risk to the body, risk to material and experiment, or just to chemical spills, just to body and the environment, they decide how important it is and what safety precautions to take. So our conclusion on this one is that the selective and variable compliance enacts professional expertise in the interpretations of risk, what hazards exist, what is threatened, and the probabilities for control by following regulations or not. And the discretionary compliance is part of the technical and practical assemblage of the local culture. And then we have a third one, which is analyzing the inspection data. And I want to get to this one because my conclusion and my question for you to think about comes from this one. So in this study, we analyzed the inspections for 10 years. That's twice a year, 14 waves. Well, I don't know how 10 years gets to be 14, but that's what it is. 306 labs discovered 13,000 violations over that period. And what it looks like is something like this. The orange line is the number of accidents. So there are not so many accidents. The blue line is, oh, I got it backwards. The orange line are the inspection findings, and the orange line are the inspections. The blue line is the accidents. So that's right, not many accidents. But what it looks like is once they find something wrong, the next inspection, nothing so much, then something. That's the pattern over 10 years. But the number of findings is going up over this period. That was worrisome because the purpose of this agreement with the Environmental Protection Agency was to create a system that would observe itself and make corrections. So how from 2006 to 2012, you end up with more and more problems. Now, it could be that the inspectors are just being more careful, they're observing more, but we know that the rules didn't change and the actual inspectors didn't change. But when we looked, it turned out that that increase over time was not everybody, it was some. We divided on the first inspection into quartiles. And if we look and you see the ones who had the most violations in the first inspection end up getting worse and worse with time. And this is our most recent publication, and we want to know who they are and why. And it turns out that within any department or between the departments, they vary. It's not important. And it turns out that individuals within a department vary. See this light blue line? There's a bad guy, okay? And this brown line is another one, though he's gotten, after he had a really bad inspection, things got better. But then this light blue one down here got worse over time. And this is what we're trying to explain. And we explain it by looking at the age of the actor, the gender, whether they're tenured, what rank they have, and the size of their budget and the number of publications. And what do we find? That basically, the more money you have, 75th to 95th percentile, the worse your lab is in safety. Now that's pretty interesting. And what does it show us? That these are labs which are crowded, which have so much money, they keep hiring more people, they keep buying more equipment, and they become less safe. Okay, so the conclusion here is the safety is not, that the system is not effective in reducing the number of observed violations, that there is a differential reaction to the system beyond what we observe between biologists and chemists. It's something else. And in labs where the PIs hold higher status is what it is, there's more safety problems, okay? It's not that they're more productive science because we controlled for the number of publications. It's just that they are crowded, they are growing, and it turns out that the scientist doesn't pay a whole lot of attention. So the status hierarchy within the university turns out to be a problem for regulators who occupy lower status positions in their efforts to monitor. We observe this status hierarchy that some people are protected and the high status clients don't take it seriously. We interviewed, but we're not going to, but that's basically what the inspectors told us. They agreed that the scientists' involvement is the main factor that contributes to the success or failure. And basically, when you have more money, more people, they're just less involved. There can be deliberate avoidance, but the faculty just think they're overworked and they can't handle it. So we're back to square one. So most PIs comply, but there is a percentage like that normal curve with which I began at the left side of that curve that are non-compliant, okay? Now, this is the model. Inspection is conducted, some conform, some get updated, but what happens is that the conformists get more and more regulation and the non-conformists still regulate. And that's the problem I want to leave you with. So what I've shown in this study of scientists is that they are like ordinary citizens. Their subjectivity and consciousness varies and their compliance with regulation varies. The variation is professional, by discipline, by local lab culture, as well as by individual habit. The scientists recognize a wider range of hazards than does the law, and they use their expertise to decide how to respond. Now, what we think is that when it works because regulation is pragmatic. It rejects one size fits all. It adapts to local variations. But this leaves us with a theoretical and policy dilemma. How can we embrace or differentially manage variation and at the same time serve equal justice under law? And that's my problem now. And I am struggling with it because nobody wants to fire or punish the people who don't comply, but can we apply different processes to different persons? How can we make regulatory compliance pragmatic friendly? That's a challenge, because when it has been varied in the past, it has been in some senses corrupt and benefited, as it is here, benefiting the most elite and the most high status. So what does an organization do? All right, we return to these outliers in the distribution, those persistent 5 or 10 to 15%. All right, this is an issue for public policy, not just for environmental regulation or safety regulation. It is something that our sociology should be able to address. When we observe problems, we write rules, we offer training, okay? Now I'm talking here not just about environmental health and safety, but we do the same thing, at least in the United States, on harassment. And for gender or race, we make everybody get training. Well, the truth is everybody goes for training, and you still have 5 or 10% of the people who are harassing, who are discriminating. And whether it is safety or whether it's harassment, the problems lie in a small segment of a population you are not willing to make outcasts. And how do we handle that? Okay, that's my problem. All right, the good guys get more and more regulation, and the deviant actors persist. So I conclude by asking you to help me. What should we do? We can live with such normative variation in most instances. It's what makes the world interesting. And then we can respond, all right? We, officials, compliance agents, we can respond and just handle the outliers one by one. But in circumstances of serious hazard, can we tolerate a persistent population of nonconformists? I take this to be a theoretical and a practical challenge. It's not just a matter of making outliers, as I said, into outcasts, because as Durkheim explained, whenever you raise the bar, there will be some angels who are insufficiently righteous. What should we do? That's my end. Thank you very much.